listening to Driving Law, a podcast by Kyla Lee about all things related to the rules of the road.
Hello and welcome to another episode of Driving Law. I'm Kyla Lee at Acumen Law, and with me, my co-host, Paul Doroshenko.
Nice to see you, Kyla. Glad we could slip in a few minutes here to record the podcast.
Yeah. Well, we didn't have one last week because of Good Friday, which we've intermittently sometimes had them on Good Friday and sometimes not. We're not very consistent about that.
Well, again, the whole day's gone. So when are you going to do it? And then somebody else has to put it together and post it. And that's Paran. We're not going to ask him to do it on Good Friday. So at best, we were going to get it on Saturday, unless we did it beforehand, if we were like organized enough for that, I suppose.
Yeah, fair enough.
Yeah.
Well, anyway, we have interesting cases to talk about. As you know, I've been producing my newsletter. Did you know my newsletter is up to 70 subscribers?
Oh, good.
You know,
Excellent.
70 people actually want to subscribe to my thoughts on impaired driving case law.
Yeah, you think of people here in lawyers here in Vancouver may be so full of themselves that they don't necessarily want to follow you. But across the country, people know that you're the Brainiac 6000 supercomputer. So yeah, it doesn't surprise me at all. I'm always surprised that people don't know about some of the things that you do. Like I posted a TikTok this week just to talk about your book on cross-examination, which, like if you don't continue to talk about it, people forget about it, but it still sells very well. But one of the commentators
forget because they buy it.
Well, I know. Well, they get the notification and they find out about it, but you don't talk about it. And I posted this TikTok complaining about the fact that you don't talk about it. And one of the people who commented on it was your cousin, who said, I didn't know she wrote this book. I'm like, she's written 2 books, like 3 books if you include the children's book, but 2 textbooks, and the cross-examination is like hands down the best cross-examination textbook that there is out there. And commentators were saying that too, but you don't talk about it. Where was I complaining? How did I get on this complaining track? Yeah, people forget what you do if you don't talk about it.
Fair enough.
You got to be a little self-promotion from time to time.
Excuse me, I get flack for being the queen of shameless self-promotion.
I think about it back in the day when the IRP scheme came out and I was on like TV every 2 weeks. And then you were on TV like every second day for years. People knew you, but then now there's not that many people watching TV, and now everybody knows you from TikTok.
Yep.
But for TikTok, you might be forgotten. You got to keep people reminded about the fact that you're producing quality stuff all the time.
Okay. Well, let's make this podcast quality and not just the Kyla pep talk. So interesting case out of the Quebec Municipal Court. Case called
From your newsletter? Is this from your newsletter?
Yes, this is from my newsletter, but I think you're going to be very interested in this because it's a positive case following the Supreme Court of Canada's decisions in Larocque and Roussel about the certificate of analyst for the alcohol standard. Remember how in those cases the court would shut down the argument that was working, the old Goldson argument that you had to actually file the certificate of analyst and all of that. So yeah,
evidentiary shortcut. You want to prove that point?
Yeah, you'd think that those decisions would make it a lot more difficult to succeed on any other argument surrounding the elements that have to be proven for the presumptions. But in fact, the Fillion case opens the door a bit.
Okay, so what do we have?
So, in that case, it's a disclosed, so it's a Stinchcombe or O'Connor application. One of the issues was whether or not the first or third party records regime applied. And the accused wanted 3 things. First, she wanted the CRPQ database records, basically like the Prime database equivalent in Quebec, for any searches of their vehicle. Number 2, proof of the qualified technician's designation as a qualified technician, and 3, proof of the competency training for the qualified technician, because as you know, they have to do the recertification every 2 years. So she wanted proof that that was done, that they were within their competency, that they were designated as a qualified technician by the Attorney General, and then this Prime database record search.
Yep.
So the court agrees with her on 2 of the 3 matters. Basically, the prime database, there was no evidence that any search had ever been done, and like no basis to establish any likely relevance, particularly in the absence of any evidence it was ever done.
Anytime I've got that information, I've never found that I've never found that it's useful. It might, it speaks of something, but it's never had something that I could cross-examine somebody on or anything. So,
Yeah, I mean, it might be useful in cases where you're trying to establish, for example, that a stop was arbitrary and racially motivated or motivated by like a ruse, right? If you think the police stopped your client because he's got a history of drug trafficking, but they pull him over and they're like, "Oh yeah, we're just checking your license status." If they did a prime query immediately before pulling the vehicle over and it came up with all those hits, that would be evidence that would support that argument. So I can see ways in which it would be relevant.
fair.
But the court called it basically a partie de pêche or a fishing expedition. Yep. But then
Okay.
on the more important things, I don't care about the database because they don't rule it out that you can get it. They just say it's not relevant here and it's not yeah, there's no reason to get it. The 2 more important things, the court said, "Oh, absolutely, those have to be turned over." And even though the information about the designation and the proficiency testing were not in the possession of the whatever municipal police force had stopped the accused or the Crown, I don't know why. Well, whatever. They determined that it was still first party disclosure, relying on govens for even though they're not in possession of it, that doesn't necessarily mean it's automatically third party because it's also things that should be in the investigative file in possession of the investigating body.
It's the whole point of having that technician conduct that search is that they are qualified to do it for the purpose of collecting evidence. It better be in that, better be available to them.
Yes. And so after finding that it is a first party disclosure, the court concluded that yes, it had to be disclosed. And the Crown's whole argument was, well, it doesn't matter because we have presumptions and it says it on the certificate that they're qualified technicians. So because of Roussel, we don't need to worry about proving anything that's on the certificate anymore.
More than once, I've had a qualified technician who had expired credentials.
Yep. And the court rejected that argument and said that the request for proof of designation as a qualified technician is something that must be disclosed because status as a qualified technician is a necessary precondition to the presumption of accuracy. And so it's not a merely collateral piece of evidence. It goes to the core of the reliability of the Crown's evidence. And the certificate alone does not suffice because the Crown still bears the burden of proving all of the preconditions necessary for the admission of the certificate for the presumptions to apply.
Yeah.
There's a nice little French line in the judgment. It's a French judgment. Nice little French line that says, l'application, my French is very bad, l'application d'une présomption ne se présume pas. The application of a presumption is not presumed.
Presumed. Yeah. Okay.
Yeah, I love it. Love it. The
Application
application
of
of a
presumption
presumption is not presumed. I'm going to use that in court now. It rolls off the tongue real good.
Yeah.
And same thing for the
That's really good.
recertification. Sorry?
That's really good.
Love that line. And so, yeah, any doubt about whether the operator was qualified obviously undermines the reliability of the breath test results. And so, in response to Roussel, which the Crown, of course, and Larocque revoked, the Crown was like, no, 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 it is supposed to simplify proof in these cases. And the legislative changes are meant to streamline and reduce these technical disputes. And the judge like really pushed back on that. He was like, no, 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 you're reading Roussel in an overly broad fashion. It's not about every single fact on the certificate doesn't need to be independently proven. Roussel's just about that certificate of analyst and that it doesn't need to be filed. Plus, Roussel and Larocque still make the point that it's got to be disclosed to the accused. And so if that had to be disclosed to the accused because proof of it is a necessary precondition to the application of the presumption, then so does all the other stuff.
That's great.
Yeah.
Good. Solid.
So the foundational requirements still have to be proven, which is nice.
Good.
And each condition of the presumption does not presume itself, is another line from the case. So great stuff in there.
Yep.
Yeah, I was
What was the
very,
judge? What was the name of the judge?
no, I don't know.
Remember? Okay.
No, sorry.
Mm.
So something I pay attention to,
Anyway.
unless it's BC where I might know the judge. Okay, I have another good case for you too, though.
Okay. Oh. Oh. Okay.
This is a case about language barriers, which is something we deal with so much here in the Lower Mainland.
We do.
Yeah. So this case, it's Miss Jiang, and it's out of Ontario. And she's pulled over. She's a Mandarin as a first language speaker, which of course lots of our clients are. Lots of people who get stopped by police are in the Lower Mainland. And she testified at trial, but through an interpreter, and basically said, "My knowledge of English is rudimentary." And when she was arrested by the police, he didn't get her a translator when he was doing anything like reading any of the demands or any of the charter rights and warnings.
Well, that's no good,
But
especially when translators are available. Anyway.
yeah, but he did get a translator when it came time for implementing the legal aid call.
Yeah. Okay. Well, now I'm looking forward to seeing where this goes.
Yeah. So there was also evidence that in the breath test room, the video of the breath testing, she was really struggling to provide a sample, and she like didn't do what she was being told to do, and the answers that she gave to the instructions for the officer were like they didn't make any sense. Which, I'm sure the police just interpreted as sign of intoxication, as they
Yeah.
do.
Yeah.
Um, but the court looked at that and said, look, like that's evidence that kind of proves her point that she didn't understand what you were telling her. And now you're gonna, tell her that she didn't have the right to have the matter um dealt with in Mandarin. And so the court says that in circumstances, well, in special circumstances is what the court essentially rules. You have a constitutionally protected right when dealing with police to have somebody interpret for you for the purposes of your charter rights, your instructions on demands and compliance with things, that is a constitutionally protected right if the special circumstances exist. Like that it's obvious, it should be obvious, it would be objectively obvious that you don't you struggle in English or French.
You know, I understand that rationale. It's basically been the rationale that we've used in BC for my entire legal career. Um, but what happens when you run into somebody who speaks like some language that there's no interpreter for? Like it's one thing if it's Mandarin, but it's another thing if it's Urdu or something like that. Like if it's if you've got somebody whose native language, they've come to Canada, they're living in Canada, they managed to get here on a work visa or whatever, refugee status or even vacation, and they speak some language that's like impossible to find a interpreter for.
Yeah.
How are the police supposed to deal with that?
I would say that in that situation, obviously it's not covered in this decision, but if I were the Crown and if I were answering that question from a judge, this is what I would say. Obviously, you can't have an interpreter at the ready, especially in the middle of the night when most impaired driving investigations happen, for every possible language someone could speak. But the police need to make a good faith effort to find an interpreter. There are interpretation services available. There are officers maybe on duty who speak those languages. They have to make the good faith effort. And if they make the good faith effort and there just isn't an interpreter, then, maybe a technical breach would be found. Maybe a more substantive breach would be found, but on 24-2, it would favor admission of evidence, not exclusion of evidence.
Well, I can think of so many things the police could do, like having a ready list of interpreters.
Yep.
Per province, you might not be able to get the person, but at least you can try.
Or like
List.
we have at our office, we have multiple language speakers here. We have a little list of who speaks what languages. So if people call and they need help, we know who we can put them on the phone with.
Exactly.
We have someone who speaks Urdu, for example.
We're not we're not letting you speak French to anybody.
Thanks. It's, I try my
Or
best.
me.
Uh, um, plus, I mean, now, honestly,
The pot parlay.
now you just get your Chat GPT app and be like, hey, I need to tell somebody this in French. Can you say it for me?
You could.
And it'll do that.
But you wouldn't necessarily, I wouldn't be confident of my understanding of somebody. Like I listen to CBC, the French SRC radio all the time, and I'm always surprised how much I understand. But then I realize, oh, they're talking about music. They're talking about some political thing that I also already all know about. So
Yeah.
I would never do it.
Well,
Anyway, it's a good case. Good decision.
yep. She was deprived of her meaningful ability to understand and exercise her constitutional rights. And the court excluded, in that case, everything under 24(2), finding that although the officers didn't act in bad faith, the failure to provide a translator was like tantamount to not providing the right to counsel at all.
That's what I was about to say. You know, when it's a 10B violation and your right to counsel is blocked, everything's always inadmissible. Doesn't matter what.
Yeah.
And so in those circumstances, that makes sense. And it's hard to patch that up.
Yes, it is. Yeah, I would agree. It is hard to patch that up. There was one other case I wanted to mention, but I seem to have lost my note about it. So why don't you talk about a few things? Just could you
Kill some time.
no, what is it?
It's song.
There's a term for it. There's a musical theater term for it. Vamp. Could you vamp for a second while I find my note?
I don't think I'm gonna vamp. I struggled this week with the ridiculous driver of the week. I can tell you that. We can talk about my struggles because there were so many of them. There was like some very good videos of high-speed chases and all sorts of things. The most upsetting one was the one that I selected in the end. Have you found what you were looking for?
No. Keep
Okay.
vamping.
Continue to vamp. Okay, well, what else can I tell you? The weather's turned lovely here. There's been no change in enforcement with respect to cell phone tickets. We are now on to slow down, move over a month in British Columbia. If the speed limit's over 80, you're supposed to slow to 70 if you're passing any emergency vehicles. That includes tow trucks, things with amber lights on them, police cars. And if the speed limit is under 80, you're supposed to slow down to 40. And I was on Mike Smith and I was asked about how many times have you seen people who are issued these tickets? And I was like, well, I don't know that I've ever defended somebody who was issued this ticket. I do know people, you know, I have had consults and I do know people who have got those tickets, but very hard for the police officers to enforce that. Go ahead.
Okay, I found it. It's a very important case. It's called Giroux, and it's a right to counsel case. It's also out of Quebec. Quebec is like the new Court of Appeal of
New
Saskatchewan.
Saskatchewan. Yeah.
Yeah. Um,
Quebecers would not like that.
who wouldn't? Oh, Quebec.
Quebecers would not like to be the new Saskatchewan.
Well, okay. So in Giroux, it's all about the right to counsel. And Mr. Giroux, roadside, he is offered a lawyer. He invokes his right to counsel. And the police say, hey, you know, if you want to talk to a lawyer here, we can't guarantee privacy. But we can also, you know, put you in touch in private later. And he's like, okay, later. And so then they put him in the police car and they drive him 25 minutes to wherever they're doing the breath samples. And then they go inside and then they put him in touch with a lawyer. And the court finds that that is a breach because they should have their obligation to facilitate contact with counsel was without delay. And if they couldn't facilitate a private conversation at the roadside, which fair enough, they, as soon as they got into a situation where they could facilitate a private conversation, like pulling over somewhere where it could be done in private, then they needed to do that. So essentially, like the court says, it's not a binary proposition between a person having an available phone at the roadside or speaking at the station. The obligation to facilitate contact with counsel is like an ongoing, non-procedural, actually substantive obligation. And the police have to make efforts to make immediate contact with counsel available.
So you can't do it with private in the back of the police car. They could always put you outside, let you
Yeah.
take the call, and the police officer sits inside if you're not in a position to run.
I mean, you pull over in like a park and they go into an outhouse. I don't know. Like,
No, I mean, if you're outside, you're on the edge of the highway somewhere, there's cars driving by, pull over, put the phone on speaker, set it up on the trunk of the cruiser. The police
yeah,
officer can sit inside. You can watch the person with the mirrors. You can't hear anything that's said.
it's not going far.
Yeah.
Yeah. Isn't that wild? Like,
That's gonna, ooh, that'll be appealed. That'll
yeah.
be appealed.
Yeah. The police, once they got to the police station, they called his lawyer of choice and they left a message and his lawyer didn't answer. And they went back and they're like, well, your lawyer didn't answer. You can call legal aid. And he
That'll,
was like,
well,
okay.
that's decided law, so maybe it won't be appealed.
Yeah. But I mean, they could still appeal it in order to get the ruling on the thing and knowing that they're going to lose on the other issue.
That's true. Yeah.
Yeah. Anyway, those were my cases. Lots of interesting cases, but
Good cases.
the Giroux one, wild.
Now you want to get to the ridiculous driver of the week?
Yes.
It's one you have to see. You got to find the video of it because it's so
Video's
upsetting.
disturbing.
It's very disturbing. When I was learning to drive, my father always said, never shift gears on railway tracks. He was trained to do that. And I think the reason that he was trained to do that was not so much the danger of shifting gears. You're not likely to stall when you're moving, maybe if you're going
Yeah.
very slowly, but it was to remind you of the danger of railway tracks. And video these days has reminded us of the danger of crossing railway tracks. There's so many videos on TikTok of semi-trailer trucks and things like that getting destroyed. I'm terrified of driving across railway tracks, but there was nothing more frightening than this. A school bus driving across the railway tracks with not enough room on the other side for the bus to like squeeze ahead, and a train coming. And the kids could see the train coming, panic on the bus, and it clipped the bus just barely. Didn't move the bus, but you can imagine the horror for those children. I'd be spend the rest of my life shaken up because of that. I hope the school bus driver is fired. And it's rare that I say somebody should be fired for a one-time mistake. But in that case, they should be fired. Where did it take place? It was in Florida?
Florida, yeah.
Yeah.
'Cause the kids were so terrified.
Oh, understandably so. I've been thinking about it ever since I saw that video. I was thinking, what do I do as a kid? Do I like open the emergency window and jump out before the train hits us? Like, I probably would have been thinking something like that, knowing how my brain works, right?
Yeah.
I would have been
You could have
screaming at
probably
that bus
MacGyvered a
driver.
new set of tracks for the train to go around the bus.
Yeah, I would have been screaming at that bus driver to pull ahead. But you never know. Like, you're a bus driver. What happens if you have a heart attack at that moment when you're just driving across the railway tracks? There was another incident I saw on TikTok today of some trucks on an airport driving across a runway, and some planes that were taxiing that had to slam on their brakes. And one, thinks that maybe buses should be equipped with something when it comes to railway tracks to remind the driver you're still on the tracks.
Yeah. I mean, it would also be nice. I don't know why they can't engineer a sensor for railway tracks that, like, if the train is within proximity that would allow them to stop before getting to a point of collision, that something is on the tracks and not moving.
Well, that's the other thing. Like, I look at the speed that trains hit things on the tracks, and I have to think that they've made no attempt to slow down. And that train looked like it made no attempt to slow down. And I know, I mean, a train flying along at high speeds, it takes a long time to slow down, but never looks like they're ever even in any emergency braking. Can you imagine if you were the engineer and you saw a school bus up ahead on your tracks?
No, I don't want to imagine that.
I know, that's the thing. Yeah.
Okay, well, ending the podcast on a dark note.
Well, it was ridiculous though. It had, and it had to be said, Kyla.
I know. If you have a driving law related issue that you need a lawyer for, you can give us a call at 604-685-8889 or find us online at vancouvercriminallaw.com and tune in next week for another exciting and hopefully brighter episode of Driving Law.